Hi, folks. Welcome to Smart Living. I am so excited because I have Chris Payne, who is a local lawyer here in the Valley, and he actually happens to be my lawyer, and he has gotten me legal. He's gotten me going in the right direction when it comes to making sure that my money is going to go to the right people when I die. And I asked Chris to come on to the show to talk to us about being smart with your money and planning it. Now, we work our whole entire lives. And usually, as parents, if we have children, we want to make sure that our children get the money when we die. So, trust and wills. Why are they important, and what's the difference between the two? Chris, welcome to the show.
Thank you, Daphne. Thank you for having me. I really appreciate it. As you know, I'm an estate and probate attorney, and one of the areas I specialize in is helping people plan for their legacies using certain tools like wills and trusts. Now, why are they important? Well, I tell everybody you should have them, especially if you have assets that you want to pass on after you die. A will can do that, but it comes with the process called probate. Probate is expensive and time consuming, and often needs an attorney to help you guide your way through it.
So pause really quick. I just
Sure.
wanted clarification. So if you don't have a trust or will, and let's say unexpectedly I die today, so what will happen to my assets and all my money and all my bank accounts and properties? It would go to probate, which is basically another court system, and that costs money.
Exactly. It would have to go through court, and that would be what we call an intestate probate, meaning no will. Testate means a will, intestate means no will. And so if you go through an intestate probate, the court will supervise the probate, making it even more expensive, and it will follow the statutes that designate who gets what in what particular order. Typically, that's going to be your spouse first, then your children, then your parents, and then from there it gets kind of complicated. And in the very rare occasions when the courts can't find any heir, and we start with going to your grandparents and then down their lines of succession, if there are no heirs at all, then the state ends up with all of your assets.
Right. So this is something you really don't want to do. You've worked your whole entire life. You want to, when you die, you want your money to go certain people, but yet you didn't do the simple thing of getting documentation done to tell people where that money should go. And that's why we have wills and trusts.
Absolutely.
Okay.
Daphne, you couldn't have said it any better. That's exactly right.
Right. So I always call this, when I talk to like my friends and stuff, I'm in my 50s, some of my friends are in their 60s. We're all relatively healthy. We're not thinking that we're going to die, but you can die any minute. You don't know what can happen. And so it is dumbfounding to me that people don't have wills and trusts. It is not that hard to get one.
Actually, you're correct. It is not hard at all, especially when you're talking about a will. A trust can be a little bit more complicated, but you're exactly right that we don't know when somebody's going to die. If I may share with you just a personal story that you know about. My son was killed when he was just 20 years old in a hit and run accident.
Right.
And nobody expected that.
No.
He didn't, I didn't. And so it can happen, and it happens every day. In addition to people dying every day, people become disabled every day, maybe incapacitated. Accidents are a very common occurrence, whether they're pedestrian, car, or just head-to-head accidents. They happen every day. So tragedy can strike at any time. Having a will and a trust is a way to prepare for potential tragedy. And if you do it today, you may not need it for 30 years.
Right.
But even if you don't update it, at least you have that. And then you've got a probate that you can do informally with a will, as opposed to the more expensive and strict process of a formal probate when you die intestate without a will.
Right. And I took you away a little bit from where you were going, because I originally had started the podcast asking you what was the difference between a will and a trust. But I wanted to clarify for people, if they don't have a will or trust, what happens and what that probate is.
And that's important. Most people ask me that question first.
Okay.
What happens? Because, quite frankly, only 20% of the people in the United States who should have a will or trust actually have one. And fortunately, you're in that category
I do.
So that means 80% of the people are leaving it up to the courts to decide where their money and assets are going to go.
Right. And you're giving the money to the courts because you have to pay them for the service that they're providing.
Exactly. So let's talk about what's the difference between a will and a trust. Both are basically roadmaps for how you want your assets to be distributed after you die.
Mm-hmm.
A trust has the advantage of it also can provide some protection or direction when you're incapacitated, so before you die.
Okay.
A will does not do that. You would need something like a power of attorney in place as well, which we also recommend as part of your estate plan. All right, so the other advantage to having a trust is you can avoid probate with a trust. Now, it's a little bit more expensive up front to create that with an attorney, but overall less expensive and quicker, and it's also private. When you go through probate, a will becomes a public document.
Okay.
Anybody can see who you decide to give money to, depending on how the will was written, how much money you decide to give, and basically all of your business is now effectively in the streets.
Okay.
A will is not recorded. It does not become public. It doesn't need to be filed in a court proceeding.
A will, or you mean a trust?
A trust.
Okay.
Sorry. Yes,
so a
trust.
will is public information,
Absolutely.
but it'll do the same thing as a trust will in terms of giving your assets to the person that is the beneficiary. But the will is public, the trust is private.
Correct.
And the trust will cost you a little bit more money.
Upfront.
Okay.
A will cost you more money in the long run, or your heirs more money in the long run, because they'll have the cost of an administration. And if they happen to need any of the money or assets that you plan to leave them quickly, it's unlikely that they will be able to get access to those funds quickly if they have to go through probate. Whereas through a trust, it happens much more quickly.
Right. So it could be like within a day and then the money's funded because it's very simple. They have to follow what the document's written, what you chose.
Absolutely. Provided somebody funded their trust appropriately.
Right.
And did all the necessary designations.
Exactly. So with the other thing with a will and a trust, let me ask you this question. You're a lawyer. So because you know I'm cheap. So whenever I hear I have to, in order to get something done, I have to go through a lawyer. You don't necessarily have to go through a lawyer to get a will and a trust, right?
Well, that's a good point. You don't. What you give up by not going through a lawyer is the professional advice of a lawyer. And believe me, having sat in numerous consultations with clients and potential clients, there are lots of questions and lots of different and novel questions that get asked that you probably want the professional advice of an experienced probate attorney. But the short answer to your question or to your statement is absolutely you don't need a lawyer. Let me give you a good example. In Arizona, you can do something called a holographic will.
Okay.
And a holographic will is, by definition, a handwritten will. There's some things that you have to include in your handwritten will to make it effective. For example, you need to make it clear that this is your testamentary intent, that you
are of
sound mind, that you have the capacity to do it. Those are things like over the age of 18 and I am of sound mind, and this is what I have, and this is who I want it to go to. So the terms have to be clear that you're distributing your assets to someone specific or an entity, a charity, or something like that. And then as long as you sign it, it's in your handwriting, that's a valid will.
Wow. Right? That's huge.
Now, it still will have to go through probate, and a court will have to validate it. But that is a way to do it without an attorney. As you can imagine, there are a number of places where there can be pitfalls.
Yes.
Involving retirement accounts and other assets. And it still may be an involved and complicated probate, but it is something you can do today.
Right.
To take yourself out of the 20% and put yourself, or take yourself out of the 80% and put yourself in the 20% of people who have some sort of plan.
Because that's often the pushback that I get from people as to why. Number one is that they don't want to have to go through all their finances. It's filling out the paperwork is too much of a hassle. And then number two is the cost of having to hire a lawyer. So I'm glad that you cleared that up for me, because there are a lot of people that really generally cannot afford a lawyer, but they have some assets that they want to make sure to go to the right person. And it literally is simply writing it down on a piece of paper. But if you have a lot of money, or if you're well established, then I think that you absolutely need a lawyer. Like, for example, for me, I have a lot of real estate. So I feel like me writing a will probably would be fine, but I got to trust, because I need that trust to work for me, which is my next question. I know that my trust actually protects me from certain things that could happen because I have real estate investments. So it's not only at the end, it's also protection of your assets too.
It can be protection of your assets, depending on what kind of trust that we're talking about. Most of the time, we're talking about something we call a revocable living trust. And that means it really is just an extension of you. You can change it anytime. You have full use of all of your assets that you've transferred to the trust, that you can take them out, you can put them back in, but basically you just use them as if you were using them yourself.
Mm-hmm.
Because in most situations, we would set you up, like we did in your case, as the trustee of your own revocable trust. So you have full control over that. The problem can come with that type of trust is because it is just an extension of you. It's not what we call an asset protection trust. All right. So it's not going to keep your creditors from getting access to your assets. Now, if you have a business and you were to create a separate entity like an LLC, that LLC can provide liability protection for, let's say you had a rental home that you put in that LLC. If somebody were to slip and fall in that rental home, they would be limited to the assets that are in that LLC. What we would do from an estate planning standpoint is we would have that LLC be owned by your revocable trust. So if something were to happen to you, the property that's in that asset would then become part of your trust and would get distributed the way you had set out in the terms of your trust.
Right.
So in that sense, an LLC combined with your trust can generate some asset protection or liability protection for assets that are in your
So they
trust.
can't just go after me for everything. If it's that specific property, if that's properly put in my trust, they can only sue me based on that specific property and not touch all the other assets.
Almost.
Almost.
If that asset is put in an LLC, a business entity, LLC stands for Limited Liability Company, then it has some protection from the rest of your assets.
Okay.
As long as your trust is a revocable trust, it's not going to be an asset protection trust. There's a different type of trust, an irrevocable trust that we could put it in, but then your money is restricted. You don't have access to it. It's controlled by an independent trustee, which is what the very wealthy do because they can afford to put millions aside for their kids or for other purposes that they don't need to have access.
Right, and I definitely am not of that caliber.
Right, nor am I.
So that's good to know because just even having this conversation with you, I'm sitting there going, yeah, there's a lot of complexities here. I can understand why somebody would want to hire a lawyer.
Sure,
versus not.
And let me add, who needs a trust? Typically, if you don't have sufficient assets to put in a trust, you probably don't need the administrative part of that because there are other ways you can avoid probate with some of your assets. And if your entire estate, if the tangible property is less than $75,000 and the real property equity is less than $100,000, there are ways we can do what's called a small estate affidavit to transfer assets to your direct heirs without having to go through a probate.
Okay.
So many people's estates would fall into that. For example, my children don't have any assets. They probably don't need a trust at this point. However, I would probably put them in a trust because at some point they're going to need one. And if they can get it done now, at least they have something in place. And it's far easier to amend a trust than to create one for all the reasons you said before: expenses, time, commitment.
Things change.
Those things that people all procrastinate about. And when you start having children and spouses or significant others, then the conversations about dying and separating assets become much more difficult.
Right.
The other thing I would add is, why get an attorney involved? An attorney helps with a lot of those conversations.
Right.
Right? They can initiate those conversations, and I've had them hundreds of times. So it's easy for me to talk to family members about an estate plan, about the possibility of somebody dying, even long-term care, how the estate plan is going to pay for that, or what happens if somebody suddenly passes away.
Yeah.
And those things an attorney can do. They aren't exactly legal, but as attorneys, we're counselors as well.
Yes, that's
true.
true.
We can put on a counselor hat and help people manage this process
and advise.
And candidly, it's with the the death of my son and my mother, it's one of the reasons I really wanted to focus in this area, is to help people plan for the unexpected
Right.
and the inevitable.
Mm-hmm.
Right? Death and taxes. We know that those two things are going to happen. We just don't know when.
And how much.
And how much. Exactly.
So that's good. That is very good to know. So if somebody were to, let me ask you this question. So what would be, so a trust is going to cost more money versus a will. This is a very subjective question, Chris. So if you can't answer this, I understand. But what should be kind of an average cost that somebody should be able to get a trust done?
Again, that
Subjective.
the typical lawyer answer to most questions is, quotes, it depends.
Okay.
Right? And so in this case, it depends too. So let's talk first. If you don't use a lawyer, there are services out there, LegalZoom,
Mm-hmm.
Rocket, Lawyer, other online
Like do it
places
yourself
that
type
you
of
can go
stuff.
to, or you can go into Staples and pick up the forms
Mm-hmm. You can.
to do the stuff by yourself. I would say, as a lawyer who practices in this area and has studied the law and the statutes, it's not as simple as it seems, but it can be done that way. If you choose that route, we're talking a couple $100,
Okay.
probably, to buy the forms or to sign up for the service.
Okay. Or you could just write it down on a piece of paper and make sure that you add that you're of sound mind and your age and just sign it, at least to just have something.
That gets your will done.
Right.
So absolutely, that's the first step in the process.
Okay.
I would say I have a introductory package for estate planning that includes a will that pours over your assets into a revocable trust. Also includes a power of attorney that helps you manage your finances while you're still alive and become disabled, and a healthcare power of attorney that allows your loved ones or significant others to make healthcare decisions for you when you cannot make them yourselves. For example, if you got in a car accident, ended up in a coma, and the doctors need permission to make
To
some
operate on you, but you can't.
Exactly. You can't give it. So who's going to give it? The hospitals, because of liability, thanks to lawyers, are going to require a healthcare power of attorney.
What about if you don't have one?
And if you don't have one, then you have to go to court. And this is an extensive process to be appointed a guardian or a custodian of an adult individual in order to be able to make those decisions for them. And again, because it's court, it's expensive. You're going to need a lawyer for that part, and it's going to take time. It's one of the more frustrating things about our legal system is it takes time. The courts are understaffed, not enough judges, and there are lots of people who are demanding attention. So no matter your emergency, it's often hard to get to the front of the line and get a decision made quickly. The way to avoid that is to do some estate planning and have these documents in place.
That's a very important thing I didn't bring up. Medical power of attorney, to me, actually is more important than designating where your money goes when you're dead.
They're equally as important, and I would say an effective power of attorney is just as important, because there are some studies that say you are more likely to become disabled than you are to die.
Right.
And those documents come into effect and will be used when you're still alive but disabled. And in fact, both of those documents cease to exist or have any power the moment you die. So just having a power of attorney won't prevent probate. You need to also have a will and or a trust.
Right.
So let's talk about who needs what. One of the things I want to make sure that I mention for your audience is if you have adult children, anyone over the age of 18, you really should make sure that they have powers of attorney and healthcare powers of attorney, even if they don't really have any assets, because you may run into a situation where you go to the hospital, your child's been in an accident, and you expect to be able to make decisions and get information. Well, if they're over the age of 18, the hospital can say, no, we legally can't give you this information under HIPAA and other laws and regulations. You need to go to court and be appointed their legal guardian, because once they turn 18,
you have no power.
Parents, you are no longer.
And we think we do. Guardian. Right. I learned that the hard way.
Absolutely. So it's important to, and this is a good gift, a birthday gift, a Christmas gift, is to give your children powers of attorney that name you as their agent, or if they have significant others, their significant other as an agent, but to make sure somebody has the authority and the ability to make decisions if something were to happen to them. They should probably also have a basic will, just in case the small estate affidavit can't be used. You at least are now in the testate category of a probate as opposed to the intestate category
Right.
of probate.
Now, go ahead. Sorry.
And it's a good way to start a conversation with your children about what you want for your estate as you go forward.
Mm-hmm. That's true. So with the medical power of attorney, can you do the same thing like as a will? Can you just write up something on a piece of paper and say, I want this? Like, can my daughter say, I want my mom, Daphne Monroe, to be my medical power of attorney, and then she signs it?
You can. But there are some statutory requirements of what needs to be in those documents.
Okay.
The Attorney General's office, I believe, or the Secretary of State has some forms on their website specific to healthcare power of attorney.
Okay. And they're free.
A living will, yes.
Okay.
A living will, there's state-approved forms, and a living will, which is what you want for your end-of-life decisions. If you're terminal, if you're in a brain-dead coma, how you want to be treated. Do not resuscitate, right. No food, no respirator, those kind of things. So you can download those forms. Again, you can also go to nolo.com,
Rocket
Lawyer, any of those to get those forms. And it's important to probably do that because, for example, the healthcare power of attorney needs to be witnessed or notarized.
Okay. So you do have to have a formal form for that. You can't just write on a piece of paper like your will.
Whereas a will, there's a statute for a holographic will that doesn't require what a will typically does, which is 2 witnesses,
right,
and your signature.
Okay, so you can get around that for a will, but you can't get around that for medical power of attorney.
Correct. It still has to be properly witnessed in order for it to be effective and acceptable.
Okay, and I will have a link to those forms that Chris mentioned on my blog at smartshopperdaphne.com.
Fantastic. And as far as a trust, you had asked before the difference between a will and a trust. And so I tell most people, if you have one of these 3 things, you probably should have a trust. If you own a house, if you have life insurance, and you have minor children.
Okay.
Okay. So if you own a house, that is typically people's biggest asset.
Mm-hmm.
And you want to make sure you control where that goes.
Yep.
And if you have multiple children, then you can have some specific directions on who gets what,
or
whether
what
somebody,
percentage,
or whether somebody gets to stay in the house, if they need a place to live. Those kind of things can all be addressed in the terms of a trust. You can pass a house, real estate on using something called a beneficiary deed, but that beneficiary deed is a little more difficult to include the language on how much people get, who can sell it when, how to insert maybe a life estate that somebody can stay in it while they're alive, and then it reverts to somebody else. Those are all easier to do inside of a trust than they are with a document like a beneficiary deed.
Got it. So you have a lot of manipulation in terms of like being able to change things, when you have a trust, a revocable trust is what you want. That's a working trust that you can make changes as you go on.
Absolutely. We call it a living trust.
Living trust, yes.
So it lives alongside you, that you can make changes at any time. And you really, if you're going to be messing with deeds and transferring real property, you almost definitely want a lawyer to make sure you do that right and you don't mess up the chain of title in a house or trip a clause in a mortgage that makes it the entire mortgage due immediately.
Okay.
So you probably want an attorney you would want to consult with an attorney before doing that. Life insurance, again, that may be the easiest way to fund a trust or to provide a legacy for most families. If you get life insurance early enough, it's relatively inexpensive.
It's nothing when you're young.
Yeah, when you're young. And when you get to be our ripe old age, it gets to be quite expensive. Oh my God,
yes.
But if you get it when it's young and something unfortunate happens to you before you're ready, that can provide quite a large sum of money for your children, right? Whether they're adult children or especially if they're minor children, you want to make sure that you set up a process where somebody can help them manage that money. So with a trust, what happens is we would create a subtrust for the minors to handle that money until they reached an
Right.
age that you designated. And even for some young adults, you might want the same thing.
Yes. Or if you
Right?
know that your child is a little bit of a spender and not so much of a saver, you're like, oh, hold off on getting that money. I agree.
And so we say from the grave, you can continue to exert some
That's
control or
exactly right.
parenting through a trust.
That's exactly right.
Right.
Throw them a little loophole there. They're thinking they're going to get their hands on all that money. Be like, not till you're 50. Not till you're 50.
Well, it's important. Some people, their family legacy is education, and they really want to encourage their children to go to college or to have education. So I have written trusts where that's a condition in order for children as they get
I
older
think that's great.
to get their lump sum of life insurance money or other assets, is that they attend or go to college or some other institution, get vocational training, something that from the grave where
Yes.
we are more comfortable that they have launched into adulthood.
Right. It's
properly.
almost like, wow, this is interesting because now I'm like, wow, I can still control my daughter even when I'm dead. Just got to get a trust.
And some people take that to an extreme. And then the last category is if you have minor children, the same thing.
Yeah.
You want to know who's going to help them with their money, finances, other life decisions. And often using a trust, you can pick a trustee. Any money that they might get from life insurance or other assets will be well managed by somebody you've chosen as opposed to somebody the court chooses. In terms of getting appointed as a conservator or guardian, your trustee can manage and take care of your children. And it may be somebody to raise the children and somebody else to handle the money to provide those people assets or funds to raise your children.
Okay.
So those three categories, I would say, if you have any one of those, you should discuss a trust,
Okay.
a revocable trust with an attorney, preferably.
That sounds good. Well, I will say for such a dry topic, we have talked about this for about 25 minutes. So that's great. So, Chris, the name of your law firm is called Painless Law. Is that what it is?
Painless Law.
His
yes.
name is Chris Payne. And so if you want to get a hold of him or if you have any questions, I will have that also on my blog along with those forms. So get something in documentation so all the hard work that you're doing will go to the right people when you pass away or something happens to you. So I appreciate your time, Chris, for coming on the show. And don't forget, I'm Daphne Monroe, your smart shopper. Get that trust.